SJC-11741, Maryland Casualty Company and another, the NSTAR Electric Company and another.
Mr. Chief Justice, may it please the Court, there are two issues before you today. The first is whether it is reasonable for a public utility to immunize itself for economic losses caused by its own aggravated conduct, including gross negligence and willful and wanton conduct.
Well, it didn't really do it by itself, did it? I mean, there's a tariff submitted, there's public hearings, approval required by a state agency, right?
Right. So the public utility submits a tariff to the DPU, and the DPU does hold public hearings. And
they set rates, don't they?
They set rates, yes.
And the rates are based on essentially the filings, including the limitations on liability?
Yes, Your Honor, they are based on that, yes.
Because if there were no limitations on liability, obviously that would affect the rates and the potential costs.
Yes, Your Honor.
The language comes from the utility about the language approved. It isn't drafted by the department.
Correct, Your Honor. The language comes from the utility, and then there is a public comment period in which essentially other utilities and the Attorney General submits comments. But the question here is whether or not this particular limitation of liability, which essentially immunizes the public utility for all economic losses, no matter how egregious the conduct was reasonable.
It limits the damages. It doesn't immunize them from all liability. It just limits the damages that can be recovered to certain categories.
It immunizes them from economic losses. They can never.
Certain categories of damages cannot be recovered. Others can.
Right.
So it doesn't exclude any liability for negligence or gross negligence.
I didn't mean to mislead the Court. My statement was...
misleading. I just want to clarify.
My statement is they can never, no matter how egregious their conduct under this particular limitation of liability, be liable for economic losses. Even if they commit fraud under their reading of this, they cannot be liable to their customers for economic losses.
Fraud's a crime.
It's also a tort, Your Honor. So if they make an intentional misrepresentation to their customers, which is the holding of the one case they rely on, CMG Holdings, the Superior Court case.
Intentional representation to who? Their customers or to the DP? The
customers.
Okay,
so CMG Holdings, which is the one Massachusetts case that they cite and rely on for their proposed rule that a public utility will not be held, it can limit its liability for gross negligence and willful and wanton misconduct. That case essentially said that a public utility can intentionally misrepresent something to its customers, and it will not be liable for economic losses caused by that intentional misrepresentation.
Well, if the tariff had said we're going to cap damages at $10,000, would that have been legitimate?
Obviously that's not the question here, but not if it rises out of gross negligence or willful and wanton conduct.
And why is that?
Because it's such an aggravated level of conduct. It's so easily prevented. All they would have to do is provide scant care.
Could the legislature have can the legislature enact a statute that said that there will be no damages for gross negligence?
The legislature can.
And haven't they delegated that authority to the DPU in the rate setting process?
I don't think they can delegate that authority to overrule the prior statements of this court in Ellis and in Wilkinson.
But it's just common law.
The statements in Ellis and Wilkinson are just common law, correct?
And Ellis was before there was utility regulation, right?
Ellis was before there was a Department of Utilities or its counterpart, I believe.
Were there private parties in Ellis?
There were private parties in Ellis. It was a public utility, and there was a private party in Ellis. And NSTAR itself has cited the Ellis case as the first case in which it is stated that a public utility can limit its liability through its tariff. So NSTAR itself, in its brief, acknowledges that it is essentially a tariff in that case.
But it wasn't a tariff.
It was called a rule and regulation, is how it was referred to by the court.
Okay.
So essentially the rule that NSTAR would want this court to make is that there are no circumstances, no matter what its conduct does, how egregious, for which it could be held for economic losses under this particular tariff.
And you say across the country, states and public utility commissions don't do that generally?
I am aware of only a couple of cases which NSTAR does cite where they do allow a limitation of liability for gross negligence. But most of the cases out there take it as a generally accepted rule that this is just an unreasonable use of a limitation of liability to limit liability for such egregious conduct that is so easily preventable.
So what is our standard of review? We generally, when we're dealing with public policy with regard to contracts, it's contracts that are not approved by a public entity. But we have a regulated industry. We have the DPU saying this is okay. So what's the standard to tell DPU, no, it's not okay?
Well, Your Honor, first, I'm not sure if the DPU actually said this is okay, because this tariff does not state willful and wanton misconduct or gross negligence. But to come back and answer your question, this court in Wilkinson undertook this same review. It said that a common carrier can make rules and regulations subject to the approval of the DPU, or whatever the entity was called at the time, and the requirement of reasonableness. And that court then undertook to review whether or not that particular tariff provision, which is a limitation of liability provision, was reasonable. So that's whether or not this is reasonable.
And if the determination of the DPU is, we can discuss in a moment whether it is clear enough that DPU actually were doing what you say they have done, but if the DPU said, we'll permit there to be recovery, but not for consequential damages, just for direct damages, that would be unreasonable per se?
It would be unreasonable per se to the extent that it implicates aggravated conduct like gross negligence, willful and wanton conduct, and intentional conduct.
And why is that? Because pragmatically, you're going to have a much greater scope of damages when you open up the door to those types of damages, and it changes the whole equation in terms of what is the risks that NSTAR, for instance, face when they have a non-residential customer. Why is it not reasonable to say we're going to burden you with direct cost, but we're not going to burden you with the potentially far greater consequential cost? Because if that's the case, we'd have to make some adjustments in your rates, and we don't want to do that.
Because, Your Honor, I think you have to look at the conduct that we're talking about. We're talking about conduct that is so outrageous that essentially NSTAR, in order to be liable for economic losses, would have to turn its back and do absolutely nothing. It would have to ignore a piece of equipment, basically not maintain its equipment, not train its employees, allow its employees to give switching procedures that are contradictory to its own rules in which it knows are unsafe. The likelihood that NSTAR would be liable for such conduct is so minute, but when it does happen, NSTAR should be held accountable for that.
Was there a criminal investigation in this case?
I am not aware of a criminal investigation, no, Your Honor.
Could there have been, in your view, could there have been a grand jury investigation for manslaughter?
I think there potentially could have been, given the facts of this case, Your Honor.
And I don't know whether it could have arisen out of this case, but you could certainly foresee a manslaughter indictment being handed down for willful disregard of other people's safety that's likely to result in death.
I mean, that potentially that could happen, yes.
So this kind of misconduct is not, it doesn't go without being accountable.
I mean, to some extent, it doesn't go without being accountable, in that case, to the people in the criminal justice system, but it does go without being accountable to the people who are actually injured through such preventable actions, through something that just should never happen. And really, it's conduct that is just so outrageous, it's over the top. It should just never happen.
So is there no remedy if the DPU, is it the DPU who's the approving authority?
Yes, Your Honor, currently it's a DPU.
If the DPU finds that NSTAR is acting so cavalierly with respect to safety, there's no remedy that DPU can use? Isn't there a remedy?
I believe that there can be an investigation and there can be some type of remedy, but again, that's going to result in maybe a fine to the state. It's not going to result in compensating the people who were injured.
If you could turn to you made the argument in your brief, just made it orally momentarily a few moments ago, that one cannot infer that the DPU actually meant to do what your sisters claim that they did. She focuses on the term whatsoever to mean that they meant any consequential damages regardless of the source. Why is that not right?
Well, Your Honor, you hit the nail on the head. The key language is the company shall not be liable in contract, in tort, and then in parentheses, including negligence and MGL Chapter 93A, strict liability, or otherwise. The word tort is modified by the phrase including negligence and MGL Chapter 93A. This provision obviously does not mention gross negligence or willful and wanton conduct. The DPU could have had no idea that that's how NSTAR interpreted it. That's nothing in the record concerning that.
But you started by saying, of course, it's a tort, gross negligence. I mean,
Gross negligence is a tort, and under this particular provision, it's limited to including negligence and MGL Chapter 93A.
limited. I mean, that's tort, and I mean, well, I know. I read that parentheses as in limited, including but not limited to.
But they didn't say that, They very could have well said that. They very could have well left the word tort unmodified if they wanted it to include every tort from negligence to intentional tort. They could have said, including negligence and MGL Chapter 93A or otherwise, but they didn't do that. Instead, they put the word or otherwise at the end of this list of general types of liability in contract, in tort, strict liability, or otherwise. So the term or otherwise modifies that list so that now they won't be liable for, say, contributory liability if that comes up, or if someone else comes up with another theory of general liability. And I also want to...
So your argument, I gather, is that even if you don't prevail in your argument that DPU can't do this, your alternative argument is to say DPU can do this, but only when it's absolutely clear from the tariff that they know that they're doing something which you think they shouldn't do.
Yes, Your Honor, and that's the case law, at least in the contractual context, requires that an exculpatory provision clearly and unambiguously set forth what liability is to be avoided, and that isn't here. And I also want to point out that if NSTAR is correct and the word or otherwise modifies the word tort, then that would render the words including negligence and MGL Chapter 93A to be essentially meaningless and unnecessary. Our reading of this provision gives meaning to every single term, and it's also consistent with the statements that NSTAR has made in its publication, the information and, I just want to get the name of it right, and requirements of electrical service. In that booklet, they interpreted their own liability, their own limitation of liability provision as being one that would allow them to be responsible for the interruption of electrical service if there's willful conduct and if there's gross negligence. And that's consistent with the Ellis case, it's consistent with Wilkinson, and it's consistent with the contractual decisions, the contractual cases that this court has decided when it comes to gross negligence, or at least that the appeals court has in this court, has suggested that that is the rule. And Your Honor, if there's no other questions on those two issues, I do want to touch briefly on the economic loss doctrine issue. I just want to make it clear that the Cambridge Incubator Company did suffer property damage. There's no dispute as to that, and NSTAR admits that in its brief. So the economic loss doctrine would not apply to that company as a matter of law.
You also say in your brief that they suffered personal injury, but I wasn't clear where they did or how they did.
That argument goes to the other two companies, Cedo.com and Elodia. When this particular network protector exploded, this fire was fueled for at least 30 minutes by electricity fueling the fire, and a oil tank was breached, and that burned as well, causing noxious fumes to fill this building. And so everybody in that building, on their way out, was inhaling smoke.
But was there any recovery sought by any of these three companies for personal injury?
They didn't seek the recovery for that, but that doesn't mean that they didn't suffer it. And I don't think that there's a requirement of the economic loss doctrine that you actually seek the damage. You can suffer a very small injury as a result of something that somebody else does. And if you choose not to pursue that damage, but choose to pursue another type of damages.
Yeah, well, the reason I raise it, I understand that, but if they, are you saying with respect to Incubator, because it did suffer property damage, it can get economic loss?
Yes, Your Honor.
So if the other companies suffered personal injury damage, why can't they get economic loss as well?
I'm saying they can.
But that's certainly not what's been briefed here.
I think the record does show that's been our position, is that if Cedo.com or Elodia suffered personal injury or property damage, they can recover. The economic loss doctrine does not bar recovery against them, which is one of the defenses that NSTAR has raised. Thank you.
Good morning, Chief Justice. May it please the Court. Andrea Paranish-Sweet, and with me, Barbara Drury, on behalf of NSTAR. The tariff provision that is before this Court is part of a tariff that has been reviewed and approved by what was then the DTE and is now the DPU. It limits, and that tariff has been in place since 2006.
What was in place before?
My understanding, Your Honor, is that back in 1997, when there was a reorganization of the utility company, that all of the tariffs that were then in place were reviewed by the DPU. I realize this isn't in the record, Your Honor, but my review of that is that the DPU at that point in time directed the utility companies to keep the tariffs with respect to liability in place that were in place. So while I have not seen the tariff,
I guess I'm just wondering whether before 2006, NSTAR or its predecessors had tariffs in which they assumed responsibility for gross negligence.
To the best of my knowledge, Your Honor, actually, Your Honor, I don't know, but what was in place before 2006.
Let me go to the last argument of your brother, which is, as I understand it, maybe the DPU can say there's no consequential liability for intentional torts and gross negligence, but it has to be made clear by the proposed tariff that that's exactly what DPU is doing, and the mere reference to torts and the reference to negligence in General Laws Chapter 93A is simply not clear enough to give the DPU the heads up to say you're actually excluding intentional and gross negligence from this category.
Well, I would suggest that it is clear, Your Honor. First of all, I think that it is very clear that shall not be liable in contract, in tort, then the parenthetical, including negligence in General Law Chapter 93A, strict liability or otherwise, makes it very clear that NSTAR will not be liable for consequential damages for non-residential customers in tort. Tort is a very broad term. It is any civil wrong as defined by Black's dictionary. The word including is an inclusive word. It's not a limiting word. It says including negligence, and it even adds 93A, which really isn't a tort at all and is a separate cause of action. The other...
I can see why 93A would be important to make clear, but one could argue that the reference to negligence throws off the DPU from recognizing that it also includes intentional torts.
That is true, and certainly in the CMG case where the tariff itself does, as my brother pointed out, refer to intentional conduct, the DPU did approve this, did approve that that tariff. That tariff was held to be enforceable in that case, and I would suggest, or otherwise, Your Honor, also is part of a list of actions that NSTAR is not going to be liable for consequential damages, and or otherwise indeed does cover any other actions that aren't listed here. So I would suggest to this court that it is very clear that this covers gross negligence or willful or wanton conduct. And I'm sorry.
You finish.
And indeed, Your Honor, there are hearings held on the tariffs. The DPU invites comments from all parties, including the Attorney General's office, where if it wanted to address
That's what I wanted to ask you. When there was a hearing on this tariff,
yes.
Did anybody raise this issue, the Attorney General or anybody else?
To the best of my knowledge, no, Your Honor. Nobody did raise this issue.
Now, as to the clarity point of view, how do you deal with the fact that NSTAR itself, in some communication, excluded it?
Well, I think that you need to read that communication in context with the tariff itself. So a couple of things. First of all, it's one sentence in a publication. It does say that NSTAR will be liable in gross negligence, and NSTAR is liable under certain circumstances in gross negligence. We're not standing here today before you saying that as a blanket exemption, we are exculpated from gross negligence. But what that...
They're liable in property. For property damages.
Absolutely, Your Honor, and we are not denying that at all. But what that publication does not go on to say, and what you have to look at the tariff for the tariff to say, is what are the damages in gross negligence that the company would be liable for? What are the classes of damages? And for that, you go back to the tariff, and the tariff will tell you that we would be liable, as Justice Cordy just said, for property damage, for personal injury, but we're not liable for consequential damages for non-residential customers. And I think that's important to understand, is that we're talking about a certain type of customers, the business type, the industrial, the commercial customers who actually, Your Honor, could indeed insure themselves for these losses, which then goes to the issue of what the DPU does, which is that it weighs the exposure of a utility and its liabilities vis-a-vis the rates and the expenses that we, as the ratepayers, are going to bear, and comes to some sort of balance in weighing those two, at some point, opposing positions. And in this particular case, with this tariff, and I would also mention that NSTAR is not the only utility that has this tariff in place. National Grid also has this tariff in place, has come to the conclusion that for this particular class of damages, NSTAR will not be liable, because in that way we also preserve and protect the ratepayers.
If Maryland Casualty or another insurer or customer was outraged, as Maryland Casualty is, about the result here, can it petition the DPU to investigate and maybe penalize your company?
Yes, it could, Your Honor. And to get to a question somebody asked, if NSTAR were acting in some outrageous manner, the DPU on its own has the right to open an investigation. The Attorney General could ask for an investigation to be opened. The DPU then has the authority to conduct a hearing, to investigate, to issue fines, penalties. They have the authority to turn around and cap NSTAR's return on its investments. It could issue performance standards. So there are ways in which NSTAR would be held accountable, and it isn't simply that it's just walking away from what might be some outrageous conduct on its behalf. Justice Spina, to answer your question, there was no criminal investigation in this case. However, the State Fire Marshal Office did conduct an investigation, and OSHA also conducted an investigation. OSHA's investigation found that NSTAR was not at fault for any willful conduct in this particular case. So I just wanted to answer that for you.
But do you agree that if your brother if he prevails, that there's at least an issue of fact as to whether or not there was gross negligence or willful
Yes, Your Honor. If Maryland Casualty prevails, then we would agree that whether or not there's gross negligence is a question of fact. It's not before this court today. It was not part of the decision that Judge Curran issued in his summary judgment motion. Justice Gantz, just a couple of other points about the publication that NSTAR's publication that I would also mention is that that publication, if you look at it, is dated 2009. There's no mention in the record as to whether that publication was in effect or even that specific provision existed in 2006, which is when this incident occurred. That's not part of the record. And in addition, NSTAR would submit that those provisions apply to the installation of service that is 480 volts or less. This incident did not occur out of an installation. It occurred as a result of a fault somewhere in a 13 kV line or somewhere else.
Well, let me ask you this. You argue with some reason that this is plenty clear, that it includes gross negligence and intentional misconduct. If it were not clear, would it be appropriate to interpret a somewhat ambiguous provision to exclude gross negligence and intentional misconduct?
I think what this court has the authority to do is to interpret the tariff as whether or not it is reasonable. If a tariff is unclear, I'm not sure that this court is the place where it should be clarifying the meaning of the tariff, or whether this court has the authority to say to the DPU, we are unsure here, we need some clarification, because it is ultimately the DPU that in the first instance has in the first instance the opportunity to interpret terms of its own tariffs.
But I mean, all the time with regard to the legislature, we have ambiguous provisions.
We do.
We don't say, golly, this is a tough one. We're going to send it back to the legislature.
Sometimes
so you
you
can
do.
Tell us. But we usually have to decide, and I guess my question is, if this were in that category of an somewhat ambiguous, and then we exercise our judgment to determine how to interpret the ambiguity, which we do, whether or not you'd still prevail.
I think that we do, Your Honor. I think that we do still prevail. First, I don't think it's ambiguous,
right, I know that.
But beyond that, I do think that we still prevail in the context of this tariff. I think it also should be recognized if this tariff is to be changed so that it includes if the tariff is to be changed so that it does not exclude gross negligence, that's a sea change in liability and for NSTAR and for all utilities that I think needs to be considered if such a change is going to happen. This provision shouldn't be read in isolation from the overall purpose of tariffs, which is, again, to protect both the ratepayer and the integrity of the utilities when rates are set. At the same time rates are being set, also being considered is the exposure and the extent of exposure that a utility may have, and so you have to take both into consideration. So I would respect that changing this may have an effect on not just this particular provision, but on the way rate schedules for the utility itself, and because at that point its extent and its exposure of liability becomes much greater than it is right now.
How often are tariffs set or filed? Every year, every 2 years, every?
I tried to find that out, Your Honor, and actually there is no set schedule.
You mean this only happened because of the reorganization in 2006? No, the reorganization was
was
in 1997.
This
So
tariff was filed in 2006.
is it totally up to the utility when it chooses to file a new one, or?
Utilities have to file tariffs with respect to if they're going to change their rates on a yearly basis. That they must do. So they do have to file tariffs with respect to their rates on a yearly basis. Those filings don't necessarily, go to every single provision in the tariff, but when they're changing their rates or changing a major procedure in how they're going to deal with customers, they must file a tariff.
So tariffs don't have durational limits. Does a utility apply for a tariff that will endure for 6 years or 8 years, or does it just file a tariff and business continues until such time as they seek a change in the tariff?
That's correct, Your Honor.
And I assume if NSTAR wanted further to limit its liability, you would have to provide a tariff that would say so.
That's correct, Your Honor. And in fact, a separate provision in the tariff that's before this court today says exactly that.
If the department were dissatisfied with tariff provisions, can it ask the utility to file a new one
Yes, it can, Your Honor.
on its own?
The department could exercise that authority, yes.
All right, thank you.
Thank you.
We'll take our morning break.